want to know, I don't think I have to call anything into session. The Team Red is meeting in caucus at the present time. When they're finished, the subcommittee, the work committee, subcommittee on the HB 313 will have a brief meeting, and then the full committee will be meeting. So that's just letting you know what the players are doing. Thank you.
I think you are like 14 months. indivisible, with liberty and justice.
All right, so the next thing I'm going to do is I'm going to immediately recess the proceedings of the full committee because, as you may have noticed from the schedule, there is a subcommittee hearing that had been scheduled for 9:50. And as I said, I apologize that we're a little bit late, but I'm going to recess so that that subcommittee can do its work, which I understand will not take very long at all. And then we will reconvene as soon as the subcommittee is done. So the hearing of the full committee is recessed.
Thank you, Mr. Chair. I'm going to open the subcommittee on HB 313. It's Representative Kutab, Representative Birch, and myself. I think that Representative Birch and the whole committee raised a bunch of concerns with the bill. I don't think it's necessarily ready. I don't want to kill my own bill, but I think that that is the direction that the subcommittee is going to go. So I'll call on Representative Birch to make a motion.
I would move subcommittee support ITL.
Okay, ITL by Representative Birch, Representative Kutab, second,
I second, and can I briefly say something?
of course.
Thank you. I do want to point out that information that was given to me by somebody else, as currently in law today, it does say, as part of this adversely affecting the reputation, unless such person requests an open meeting. Somebody could, nothing's to stop them from preemptively messaging any boards in town that they feel may be about to talk about them that could damage their reputation, and preemptively say, if for the next year you intend on talking about me, I request that that be an open meeting. And then that board would be required to then have an open meeting. So I don't necessarily think that this bill might be needed because there is a workaround to it, and that's that folks can preemptively do that. I think that's much harder for people, and if people start doing that, I think maybe the towns will become asking for this bill because they won't want to have to remember who emailed them. And I think it would have to be yearly to be fair, because our boards do change every year at each election. But I think if folks email in March after new people have been sworn in and say, if you talk about me at all, I want it to be an open meeting, then it has to be open. So I think there's already a way to do this. So thank you.
Anything else? Okay. All those in favor of the ITL motion, aye.
Aye.
All right, motion carries. I'm going to close the subcommittee work session on HB 313.
All right, thank you, Representative Alexander and members of the subcommittee. I'm going to reconvene then the proceedings of the full Judiciary Committee. And I first would like to take up CACR 6 relating to the right to compute, providing that the right of individuals to use computation resources shall not be infringed. And Representative Birch, is there a member of your caucus that wishes to make a motion on this?
Sure. We would move ITL.
Right. Is there a second? All right. Moved by Representative Birch and seconded by Representative Scully. All right, Representative Birch, do you wish to speak to your motion?
Yes, and thank you, Mr. Chair. I'll be very brief because we've discussed this at some length already. The CACR is drafted is very open-ended, and I think would be full of unintended consequences in terms of allowing certain people to have unlimited use of computers and the like. So there's some language inconsistency. So for those reasons, I would urge adoption of the motion.
All right. Anyone else wish to be heard on?
Yes.
Yeah, Representative Pettigrew.
Thank you very much, Mr. Chairman. I really want to say that I appreciate the sponsors' forward thinking on this bill. New Hampshire was the first state to propose this type of legislation, and a similar, not a constitutional amendment, but a similar bill has been signed into law in the state of Montana. However, unfortunately, I think that this issue is a little too complex to send to the voters even the voters in the House among our colleagues at this time. However, I do know that there's a bill coming next session that will address some of the concerns and include safeguards that would not be addressed with a constitutional amendment.
Anyone else wish to be heard?
Yes.
Yes, Representative McFarland.
Thank you, Mr. Chairman. Similarly to my colleague, I would say that I agree that the language of the CACR as it stands is not without its difficulties. For the record, I would opine that it is important for us to recognize and defend the natural right to use advanced technologies, to use computation resources, and to use encryption, strong encryption that does not have backdoors. I think that in the interim, if we were to ITL this, we already have in Part 1, Article 2A and Part 1, Article 2B protections for our rights to privacy and our right to keep and bear arms, which are applicable here in as much as those resources have and continue to be interpreted as weapons and arms by the federal government.
Anyone else? I guess what I would say, I just sort of echoing, I think, what everyone else has said. We all received an email from Representative Ammon, for whom I have great respect, and I completely understand. I agree completely with Representative Pettinel that the raising this issue is important, and that it may very well be appropriate for some kind of legislation. To the extent that Representative Ammon was concerned about actions that the federal government might take, I understand his concern and I'm sympathetic to it, but the problem with that is I don't think that anything that the state might do would be helpful. The issue in terms of any action that the federal government might take is whether the federal government has the authority to take that action. And if they do, then the action is appropriate and would trump anything that would be in state law. But the real question would be, do they have that authority? Because if they don't, then that legislation on the federal level or action on the federal level could be challenged, whether there was a state constitutional amendment or a state statute or not. So for all those reasons, I agree with the motion of ITL. Anyone else wish to be heard? All right, I think then we're ready for a vote on Representative Birch's motion of ITL on CACR 6, and I'd ask the clerk to please call the roll.
Representative Mannion,
Yes.
Representative Alexander.
Yes.
Representative Tripp,
Yes.
Representative Andrews,
Yes.
Representative Kutab,
Yes.
Representative Perez.
Yes.
Clerk votes yes. Representative McFarland,
Yes.
Representative Scully, Representative Birch.
Yes.
Representative Newsom,
Yes.
Representative Horrigan,
Yes.
Representative Page,
Yes.
Representative Manos,
Yes.
Representative Tur,
Yes.
Representative Rombo,
Yes.
and Chairman Lynn.
Yes.
17 yeas, 0 nays.
All right. So, any objection to this being on consent? All right, we'll go on consent. And Representative Birch, may I ask you to write the report? Thank you. All right. Next, I'm going to take up whenever you're ready. You want to know when you're ready? That's what you have the amendment. Yeah, sure. Oh, take your time. It's all right.
I'm ready.
All right, we're going to turn now to HB 232, relative to the rights of conscience for medical professionals. And the chair recognizes Representative Peternal for a motion. I understand there's an amendment.
Yes, thank you, Mr. Chair. I move ought to pass on House Bill 232.
All right, do you want to deal
I'll
with the
second
amendment
that.
first? Well, I think we should deal with the amendment first, right?
Well, yes, so I'd like to put forth amendment number 2025-2932H.
All right, is there a second to the motion on the amendment?
Yes, I'll second it.
So it's moved by Representative Peternal, seconded by Representative Alexander. Representative Peternal, do you wish to speak to your motion?
Yes, thank you very much. We have had extensive conversation on House Bill 232. This amendment changes the initial bill. First of all, this is a replace all of the second replace all amendment. It was easier to just start from the second attempt and go for the third attempt. This bill removes sterilization and artificial contraception from the original bill. It changes the definition of abortion to the same one that is currently in New Hampshire statute under the Fetal Life Protection Act. We also have limited the damages, so we removed the threefold damages that were on page 3 on the amendment. It's line 19. You can see we removed the word threefold. This bill, I did have a question and a side question about how this would interact with federal law. And there is a right of conscience in federal law, but we did hear testimony that it kind of depends sometimes on who the current administration is at the federal level as to whether or not these issues are pursued. There was an example of a situation in Vermont where a healthcare provider had participated in abortion against their will and pursued legal action, but that case kind of was just dropped. So I would just like to add also, so I think that this upholds but does not preempt federal law. That this bill is about choice. This is about giving physicians an option to practice under their right of conscience. And I think that this opens up New Hampshire for more physicians being interested in working here, knowing that they could conscientiously object to something that they would choose not to participate in. And I also think this gives women a lot of choice, because oftentimes women will go to a provider and they won't find out until after they've been being treated by the provider for quite a while that they also perform abortions. And there are multiple reasons why women would not want to maybe fund a provider who performs abortions, or B, they might not even want that physician to be placing those same hands on them. So at the end of the day, I think this is a bill all about choice, giving women and providers more choice, and would increase opportunities for physicians and for other providers to come to New Hampshire for work. Thank you.
Anyone else wish to be heard? Yes, Representative Rombo and then Representative Alexander.
Thank you, Mr. Chair. I have to respectfully disagree with the idea that this is about choice for providers and for women. In fact, my first concern is that this bill really tramples on employers' rights to set schedules, to set shifts, to set assignments for any person who works in their practice or facility that may refuse care, even at the front desk, and to refer anyone for further help. When we talk about discrimination in the employment context, we talk about balancing employees' rights and also employers' substantial hardships. We are talking about rural areas with very few healthcare options potentially. To tell an employer that they can't set their employees' schedules or shifts or roles within the organization is really quite a statement in terms of our encouragement to employers in the state. Also brings me to my question, which we've asked before in session. The amended version still refers to an exception that it doesn't apply to a healthcare provider providing abortion as a major part of its services. There's no definition of what a major part of services is. Is it the majority? That's not what it says. But there aren't providers who are providing it as the majority of their services. So I'm concerned about the lack of clarity in that definition. And equally in that section defining emergency situation as an exception, who's making that decision, in what context, what time frame. And my final point here is in the statement of intent, there's two sentences. It talks about initially about abortion, and then the second one, it talks about the right of a healthcare provider to decline to participate in provision of services that they do not want to provide, that they object to. In reading that statement of intent, I have to ask, which is it? Is it objecting to any service that you have, that you do not feel like you want to provide or allowed somebody to access? Or is it about abortion? And I'm struggling with the conflict in the outset of the amendment. Thank you.
Representative Alexander, and then
Um,
Representative Tur.
Thank you, Mr. Chair. As the sole Republican holdout on this bill initially, I worked really hard with Representative Peternell and the sponsor to get this to a point where we can vote for it. I think it does button it up by including only abortions. I think that is a key component to that. And additionally, I want to outline to the committee that we did condense the damages portion as well. So at the initial bill, they had a clause that somebody could get up to 3 times the damages. We condensed that down to just the actual damages that come to it. So I think that this amendment is a reasonable compromise on the bill, and I think the whole committee should vote for it. Thank you.
Representative Tur.
Yeah, thank you, Mr. Chair. So I have several issues that were issues with the original bill that are still significant, I think, problems with the amended version of the bill. The biggest thing that bothered, well, the biggest thing, one of the bigger things that bothered me in the original bill was this is a bill about conscientiously objecting. It does not define what it means to conscientiously object. It's not an act that you have to take in a specific way or in a specific process that your employer would be aware of. This allows you to conscientiously object in your mind and act according to that conscientious objection. The implications of that are kind of huge because as an employer, you wouldn't know if your front desk person is turning people away because they don't believe in abortion. You wouldn't even know what was going on necessarily. And then sort of beyond that, if you did become aware of it, it basically says you couldn't remove that person from their position, essentially, because that would be an act of retribution. So basically, you'd be an employer stuck with somebody who may or may not be, essentially refusing to follow your organizational guidelines in any given case. And I'll go beyond that. It's not just physicians. I know the discussion in the opening was about physicians, but, it basically says, healthcare provider is anyone who, as part of his or her employment, may be asked to participate in any way in an abortion. You can be a hospital or clinic employee is a category. Any hospital or clinic employee is a category that would be covered here. And then it sort of lists some different things on page 3, so ensure that every healthcare provider is informed of his or her right to decline to do things like refer for abortion, counsel for abortion, advise, or with regard to abortion. So it's basically quite a broad list of things that are quite far removed from the actual act of an abortion that you can fail to participate in. And then I guess beyond that, the last thing is there's an implication here that conscientiously objecting is only to participate in abortion. Abortion is a safe and legal process in our world. And if you're working for a healthcare institution or you're a health or believe that you are a healthcare provider of some sort, you could just as equally say that you conscientiously object to not referring somebody, even if your organization doesn't do the procedure. Many organizations in New Hampshire don't do abortions, but they refer abortions if somebody needs an abortion. So this basically is a one-sided conscientious objection that basically says you can conscientiously object to participating in something, but you can't conscientiously object to not providing what is the standard of care, which would be to refer them to something else. So those were all issues originally. They're all issues that remain here. And with that, I hope folks can see their way clear to not advancing this. Thank you.
All right, anyone else wish to be heard? Yes, Representative Manos.
Thank you, Mr. Chair. I have several concerns about the amendment. One is specifically on page 2, line 6, in the definition of healthcare institution, nursing homes are included. And I can't understand why a nursing home would be included, except to preclude a woman who, for example, is in a coma, a pregnant woman who's in a coma or in a vegetative state who's pregnant, and the family wants to terminate the pregnancy, and this would preclude that situation. I think that's totally, totally inappropriate. The other concern that I have is that the paragraph 1 states that the purpose is to ensure that citizens of New Hampshire have access to quality health care. And I think, again, that this is extremely problematic for rural health care. Section 4 provides on page 2, lines 32 to 34, provides an exception in a emergency situation when there's only one healthcare provider available. However, what happens in a non-emergency situation in a rural healthcare setting when there's only one healthcare provider available? This essentially prohibits or precludes women in that situation from receiving quality and having quality health care and having access to quality health care. So for those reasons, I oppose this amendment. Thank you, Mr. Chair.
Anyone else? Yes, Representative Pettigrew.
Yes, thank you. I just want to address one statement from Representative Tur. I know that the conventional mantra is that abortion is safe, legal, and rare. I would argue that many people have had complications resulting from abortions, so it's not always safe. Childbirth is not safe always either. It's just the nature of who women are and how they were made. And Representative Manos, the nursing home, I think, is a red herring argument. And as far as the healthcare provider who's the only one in a rural setting, if it's not an emergency, then that client has the same concerns as any other healthcare client in a non-emergent situation in a rural setting. They're going to have to leave their area and find a provider who will do that. In fact, we have a similar bill, or not a similar bill, sorry, a bill about optometrists, because people cannot access ophthalmologists in rural settings and they have to travel long distances. So if it's a non-emergent situation, that people can travel to find the care that they need. That's the nature of healthcare in rural America.
Yes, Representative Tur.
Yes, sorry, just quickly. So first, you are correct. There's no medical procedure that is 100% safe. Safe and legal are basically terms wrapped around, what's called the standards of care, and there's a very extensive process by which we decide whether certain procedures should or shouldn't be allowed. This is one that's allowed, that's been conducted for a long time. So I don't object to the statement that no procedure is safe or legal, but or that abortion does not carry risks. Everything that we do in the medical world carries risks. I Yeah, there was another point, but I'll let it go. Thank you.
Representative Birch.
I don't mind deferring to Representative Oregon.
I'm sorry, Representative Oregon, I apologize.
Oh, no problem. That's what I get for moving over to the other side of the room. But the visit, well, abortion, this does single out abortion, and that, I mean, that does make it a more focused bill, but that's not the only common medical procedure that's religiously or politically controversial. We're in fact going to be taking up gender affirming care in another bill that's farther down our docket. There's also religious groups who are opposed to blood transfusions, psychoactive drugs, and maybe other procedures. So, we're, I think, we are singling out abortion, and I don't think that's wise because there are other. If you want to, if you're worried about the rights of healthcare professionals who object to procedures for whatever religious or philosophical reason, there are other other procedures which other healthcare providers might object to. So, so as a practical matter, in the case of abortion, there's only I think three. There's only three institutions. There are only three organizations in the state which actually provide that particular service. They're all relatively small. I suppose if the political and regulatory landscape was different, there might be more of them, but right now there's only three. So it's I think it's pretty, and there's also a shortage of healthcare professionals. So I don't think there's going to be a large number of people who have the necessary skills to work in in these professions who can't find a position with an organization that does not provide abortions. So I think these professionals already have like a good way out of this dilemma, which is to work for an organization that doesn't provide this service that they object to. And finally, we're talking about funding this particular procedure. Still, most of the funding, people, and there's a lot of uncertainty about the health insurance marketplace, especially the Affordable Care Act tax credits may be going away. But even if those don't go away, the people actually like receiving the medical care are the ones who are paying it. They should be the ones who can make the decision. So I don't think we should be worried too much if some people make decisions to use their funds and have something done to their body, even if just because somebody else thinks they should make a different choice. So I'm not too worried about the funding aspect of it. Regardless, as I said, regardless of what happens with the Affordable Care Act tax credits, which right now are slated to go away, which means individuals will be paying a lot more of their health care, and probably, of course, we'll also probably have fewer individuals who have health insurance. So the number of people who can even access any medical services will be much less. So I just think this bill is unnecessary, and it is, of course, rather limited too. So thanks.
All right, Representative Birch.
Thank you, Mr. Chair. Since I'm in agreement with the objections presented already to this amendment and to more or less the bill overall, I'm not going to repeat those. There is one aspect that shows up in legislation from time to time. We had an earlier bill on a completely different subject. But the in no case shall recovery be less than $10,000. And that makes no distinction between a de minimis, a very small mistake or small technical problem that somebody phrased something wrong or did something wrong, and some very deliberate, overt, major ignoring of state law. So I go back to what Representative Turr pointed out, that the definition of participate or participating in is extraordinarily wide. It's provide, perform, assist with, facilitate, which is a very broad word, refer for, counsel, advise, admit for. So it covers, you know, every every actual employee of these organizations, no matter whether they're performing a minor function or a major. They do something wrong, um, and they're sued, then a jury might well find, okay, there's a technical violation here. The actual damages might be $500. Pain and suffering may not exist even at all. And yet, despite how a jury might feel about it, it's going to, in no case shall recovery be less than $10,000. So why do we have that? That, in my opinion, is to frankly scare people into not getting anywhere near the whole subject, whether they're acting in a correct manner or not. Just the fear, and we find this in school systems where teachers or counselors may not want to mention a particular concept because they may be punished in very strong ways. I see no reason at all to eliminate a good chunk of what our civil justice system does, which is to have a jury decide exactly what the actual damages are and what the damages for pain and suffering. The 10,000 limit doesn't include the attorney's fee section and the like, so it would have to be just the actual damages and the damages for pain and suffering. So I don't think we should be sitting here substituting mandatory. That $10,000 is a lot of money, and I don't think we should substitute the jury system with that. And secondly, the concept that if the damages for actual damages and pain and suffering are $3,000, $4,000, the rest appears to be punitive damages. And in this state, we don't do punitive damages. So that section, with respect to my colleague from Goffstown, may have been revised a bit, but it's certainly not ready for prime time. Thank you.
All right. Anyone else wish to be heard? Yes, Representative Manna.
Thank you, Mr. Chair. Abortion care is reproductive health care. And the fact that it's difficult for people in rural areas to find and receive ophthalmological care does not mean or justify that we should make it difficult for people to receive reproductive health care in rural areas. And I think this is extremely problematic and denies people health care. Thank you.
Anyone else wish to be heard? Yes, Representative Rambo.
Thank you, Mr. Chair. I did have one more point. Earlier, we heard that this bill would be helpful for patients who might not know until starting their care that the provider they're seeing also provides abortion care. That's not what this bill does. It's not what this amendment does. It does not talk about healthcare providers and what they need to share at the outset. It does not, and frankly, it has nothing to do with whether a patient could ask a healthcare provider or facility what sort of care they're offering to other patients at the outset. What this bill does is it says anybody from a receptionist on up can refuse medical care without explaining it, without referring it, without regard to context or timing for a legal healthcare procedure that our governor has said repeatedly she hears people do not want to limit access to beyond where we are in New Hampshire. So I just have to push back on the idea that this is giving patients information that's not available. Instead, it is limiting healthcare.
Yes, Representative Penner.
Yes, thank you. To your point, thank you. Yes, I know that this bill is not about the patients per se, However, I think it would be doing a great service to the client who does not wish to have a physician who participates in these procedures. And as to the point again about rural healthcare, the maternity unit in our local hospital closed over 20 years ago, or close to 20 years ago. I can't remember exactly. But I would say that reproductive health care has been severely limited in my community for 20 years. So I don't see that how this would limit, if you want to call abortion reproductive health care. I don't believe it's reproductive because you're stopping the process. But I don't see how this would hamper somebody's ability to procure reproductive health care.
All right, anyone else wish, Representative Kutab?
I just want to thank you for recognizing me. I just want to briefly add one thing. I do agree with Rep. Turer, and I think potentially like about one of his points, and potentially it could be corrected with a floor amendment, that it should define the process for consciously objecting. A receptionist shouldn't just be able to turn the patient away without the employer knowing. I think on page 3 in that Roman numeral 2, it could also say, and the required process to object, because the institution could come up with a policy on how you do that, such as if the receptionist objects, then they have to have another receptionist cover it, or the nurse, or whatever the provider is. I think that's fair, that you can't just object, but then not say, well, I consciously object to providing an abortion, but just making the patient seem like they just couldn't get one at all. So I think that one portion could be added just to clarify that consciously objecting does mean you have to let the employer know, and you can't silently object and just not do it.
Anyone else wish to be heard? All right, seeing nothing, no further members have comments. I think we're ready for a vote on the amendment. And given the debate, I think we'll do a roll call on the amendment as well as the main bill. So the motion is to adopt amendment 2025-2932H. And we'll ask the clerk to call the roll, please.
Vice Chairman Mannion,
Yes.
Representative Alexander.
Yes.
Representative Tripp,
Yes.
Representative Andrews,
Yes.
Representative Kutab,
Yes.
Representative Perez,
Yes.
clerk votes yes. Representative McFarland,
Yes.
Representative Scully,
Yes.
Representative Birch,
No.
Representative Newsom,
No.
Representative Horrigan,
No.
Representative Page,
No.
Representative Manos,
No.
Representative Turer,
No.
Representative Rombo,
No.
Chairman Lynn.
Yes.
10 yeas, 7 nays.
All right.
No.
10-7, okay. 7. All right, so now return to the main bill, and Chair recognizes Representative Peternal.
I move ought to pass as amended on House Bill 232.
All right, is there a second?
I'll second that.
All right, motion's made by Representative Peternal, seconded by Representative Alexander. Representative Peternal, anything further you wish to say on the main bill?
No, this is a replace all, so I think we've covered everything regarding the bill.
All right, anyone else wish to be heard on the main bill? All right, then we're ready for vote on the main bill, and the motion is ought to pass on House Bill 232 as amended by Amendment 2025-2932H. And I would ask the clerk to call the roll, please.
Vice Chairman Mannion,
Yes.
Representative Alexander.
Yes.
Representative Tripp,
Yes.
Representative Andrews,
Yes.
Representative Kutab,
Yes.
Representative Perez,
Yes.
clerk votes yes. Representative McFarland,
Yes.
Representative Scully,
Yes.
Representative Birch,
No.
Representative Newsom,
No.
Representative Horgan,
No.
Representative Page,
No.
Representative Manos,
No.
Representative Tur,
No.
Representative Rombo,
No.
Chairman Lynn.
Yes.
10 yeas, 7 nays.
All right. Representative Petterno, will you write the main report? Who, is there going to be a minority report? Representative Manos? Okay. All right. And yours, I take it would be ITL? Is that ITL, okay, all right.
Mr. Chair, can we just recess for about a minute and a half?
Of course, absolutely. Yes, we'll take a brief recess.
Who up?
Where's Dan?
We're up 293. All right, I'm going to turn now to House Bill 293, preventing minors from accessing obscenity on certain electronic devices with internet access. And the chair recognizes Representative Kutab for a motion.
Thank you. I move interim study.
I'm going to second that. Representative Kutab, you wish to speak to your motion?
Briefly, we got some information that Apple is actually already complying as is written in the law, where it does, in fact, during setup, ask you to your age. And when you do the age, it does automatically set this filter. And it also allows the option for the parent to set a passcode so that the filter can't be disabled. I think we're all in agreement that we don't want minors to be accessing this sort of a thing, but it seems like it's already being done. However, this is a new thing that just came out, so we can monitor it, make sure everything's going fine. And if there should be any issues with this, new rollout or whatnot, at that point, we would have the opportunity to look into that and see how to best address it.
All right. Anyone else wish to be heard on the motion for interim study on House Bill 293? Representative Petterno.
Thank you, Mr. Chairman. We did have a subcommittee, and I was the chairman of the subcommittee on this bill. We met once in September, and we were trying to reorganize to meet again sometime at the end of October, beginning of November. It was hard to come to a quorum. And in the meantime, I had done some extensive research and thought that the motion of interim study would probably be the best tack to take on this bill. So we did have a great discussion in the subcommittee hearing or the subcommittee work session, sorry. And we agreed that it is complex for parents to determine how to set up safety features on devices. I am a co-sponsor of this bill, and I really wanted to support this because I think it would be helpful for parents to have better tools to protect their children online. However, as Representative Kutab said, we know that Apple is doing this. There is a current lawsuit in Utah about how that's being implemented. I think we would be wise to wait and see how that turns out. I do have some other recommendations for possible actions that may not necessarily be taken at the state level. And one is that the minimum age of 13 for social media accounts is primarily due to the Children's Online Privacy Protection Act from 1998. And that is severely outdated. In 1998, I hadn't even really heard about social media. It was like chat rooms, right? Back then, and I was still using dial-up. Now kids can carry these devices around anywhere they want to go and have access to porn 24/7. And this bill really is about preventing children's access to pornography. However, I'm not 100% sure that this bill in particular is the vehicle, which is why I am agreeing with the interim study recommendation. And one other issue is that we were sent an X, formerly known as Twitter, post about the possibility that Apple was not living up to its promises. But the comment on that post was that if the child is setting up the phone, so right there, the parent has given the device to the child. They've abdicated their responsibilities and their duties. So that post that was meant to encourage me to support and pass this bill actually did the opposite and moved me more towards interim study. And the other thing is I've passed this out to the committee. I have 7 pages of online safety tools that parents can access. So we're just at a crossroads here. We've seen the damages of social media and constant access to devices. We have implemented a cell phone bill in New Hampshire, and there are several states who are already seeing positive results from the cell phone bans in their states. And I think that as we move forward with that, we will begin to see limited usage of the cell phones. But I would still like to work to protect the children on these devices. Thank you.
All right. Anyone else wish to be heard on the motion for interim study on House Bill 293? All right, seeing none, I would ask the clerk to call the roll. The motion is to interim study House Bill 293.
Representative Mannion,
Yes.
Representative Alexander,
Yes.
Representative Tripp,
Yes.
Representative Andrus,
Yes.
Representative Kutab,
Yes.
Representative Perez,
Yes.
clerk votes yes. Representative McFarland,
Yes.
Representative Scully,
Yes.
Representative Birch,
Yes.
Representative Newsom,
Yes.
Representative Horrigan,
Yes.
Representative Page,
Yes.
Representative Manos,
Yes.
Representative Turer,
Yes.
Representative Rombo,
Yes.
and Chairman Lynn.
Yes.
17 yeas, 0 nays.
Any objection to this being on consent? All right, it'll go on consent. All right. And Representative Kutab, could I ask you to write the report?
Happy to.
Thank you. All right, next, we'll turn to HB 313 relative to non-public sessions at public meetings where discussion in public would likely affect a person's reputation. And the chair recognizes Representative Birch for a motion.
Thank you, Mr. Chair. I would move ITL.
I'll second the motion. Representative Birch, do you wish to speak to your motion?
Thank you, Mr. Chair. This bill was extensively discussed both at the committee level and in a work committee. I think all members of the subcommittee that worked on it felt that there was merit in the concept, but we felt that the various permutations of how this would work in real life was too complicated for this bill. The issue of what happens if two people are in there whose reputations are being discussed and one person wants it discussed publicly and one doesn't. Issues of confidential materials, et cetera, et cetera. There may be already protections within our statutes that present a workaround so that there may be relief in particular circumstances that could be followed. And for that reason, it seemed wise to go with ITL on this bill.
Anyone else wish to be heard on HB 313? All right, seeing none, the motion, I'll ask the clerk to call the roll. The motion is ITL on House Bill 313.
Vice Chairman Mannion,
Yes.
Representative Alexander,
Yes.
Representative Tripp,
Yes.
Representative Andrus,
Yes.
Representative Kutab,
Yes.
Representative Perez,
Yes.
clerk votes yes. Representative McFarland,
Yes.
Representative Scully,
Yes.
Representative Birch,
Yes.
Representative Newsom,
Yes.
Representative Horrigan,
Yes.
Representative Page,
Yes.
Representative Manos,
Yes.
Representative Turer,
Yes.
Representative Rombo,
Yes.
and Chairman Lynn.
Yes.
17 yeas, 0 nays.
All right. Again, any objection to this going on consent? Seeing none, it'll be on consent. And Representative Birch, can I ask you to write the report?
Yes.
Mr. Chair.
Yes.
If we could, before we pick up the next
Sure.
bill, can the Republicans caucus again?
Yes.
Thank you.
Before we head, just one matter before we headed out, should have said this earlier. Just wanted to welcome Representative Scully on the record, so to speak,
Yes, no,
to-
thank you, yes.
to our committee and express from both sides of the aisle that we look forward to working with them in a productive and friendly manner. And I would also mention that we have a substitute here, Representative Newsom, who is not the governor of California, but a hardworking state rep in New Hampshire. And he's subbing today, and we're happy to have him.
All right, so we'll be in a brief recess for a caucus. All right, I'm going to reconvene the Judiciary Committee, and I'm going to now turn to HCR 11, House Concurrent Resolution declaring the directives of the judicial branch in the Claremont cases that the legislative and executive branches define an adequate education, adopt standards of accountability, and guarantee adequate funding of a public education are not binding on the legislative and executive branches. And I'm going to recognize myself to move interim study on HCR 11. Is there a second?
I second the motion.
Moved by Lynn, seconded by Andrus. And guess I'd like to just speak briefly to the motion. There's no much of the sentiment that is expressed in the concurrent resolution. I'm frankly generally supportive of. I think that the Conval decision was wrongly decided. I tend to think that the dissent had a much better argument than the majority. But there are a number of reasons that I think this concurrent resolution is unwise. First of all, the legislature is going to need to respond and to the court's decision in the Conval case, and there's actually other litigation. The Rand case is still pending on other things. The legislature is going to need to make some response, and and there are proposed bills to deal with education funding. In fact, I've got one that's been submitted for redrafting, but I know Representative Ladd has a number of them, and I feel fairly confident that those bills are not going to simply say, oh, the legislature, the court said spend $540 million or whatever it is, more money on education, and fine, where do we sign? The legislature is not going to do that. At least in my view, the majority of the legislature will not do that. And that's entirely appropriate, in my view, for us to exercise our judgment. This HCR doesn't do that. It's just a statement. It's just sort of a statement, and candidly, it seems to me that it sort of is it's kind of a statement of sort of defiance that really doesn't accomplish anything, because it's only a concurrent resolution. And I think there are a number of important things to consider in deciding whether it's wise to adopt this resolution. The first one, it seems to me, that's very important to recognize is that the majority decision in the Conval case was rendered by 3 judges who are now gone. They are no longer active members of the court. They are retired. The 2 participants in that decision who are still on the court were the dissenters. And the court now has a new, and by the way, Chief Justice McDonald was recused from that case. He is not recused from the other case, the Rand case, that is still working its way through the court system. And there may be other cases that will come up. Presumably, he will not be recused from those, because the reason he was recused from Conval was he had some involvement with the case when he was the Attorney General. We have a new judge who, as far as I know, has no basis that he would be recused. So that, it seems to me, is, to the extent that this HCR is sort of a slap, if you will, at the judicial branch, I think it is unwise to do that when the judicial branch now consists of people that were not the ones that supported the Conval decision. And I think that it in many ways could be counterproductive, because to the extent that it sort of takes and the language in the HCR is pretty strong. To the extent it sort of takes an in-your-face kind of position with the court, it seems to me that that is not something that makes sense for us to do in the context of trying to preserve, a cordial relationship between the branches of government, or just frankly in terms of trying to persuade the court that what we end up doing in response to the Conval decision is something that the court should accept. If you start, I can't help thinking that if this were to pass, one of the things that it could very well engender in the judicial branch is a kind of circle the wagons mentality. We're under attack. We better circle the wagons. And I don't think that is anything that likely would produce a result that those of us who think that the Conval decision was wrongly decided would want the eventual result of this to be. So for all those reasons, it seems to me that interim study makes the most sense. I know other people may have different views of why they oppose this, but those are mine. Representative Birch and then Representative Horgan.
Thank you, Mr. Chair. I intend to vote yes on the motion. If I were running the world, which I'm not, I would be voting ITL, but sometimes you have to take yes for a yes and move on. But I do have some remarks that I want to briefly make. And it has to do with the issue of separations of power and something very fundamental to our system of government. Irrespective of whether one agrees or disagrees with any particular decision of the Supreme Court, under our system of government, those decisions are within the province of the judiciary to make, and they're binding on the other two branches. And democracy, I think, does not survive otherwise. That principle is as old as our nation is old. We are a government of laws and not of men. That was from John Adams, although ultimately attributed to somebody before him, James Harrington. We have Article 37 of our New Hampshire Constitution. It's certainly one of the oldest, is probably one of the strongest statements of separation of powers of any state constitution. And I know we're familiar with it. Basically, it says that there is a lane for the executive branch, there's a lane for the judicial branch, there's a lane for the legislative branch. And in many respects, Article 37 is a very, very strong liberty provision, because by requiring the various parts of government to stay in their lane, Article 37 prevents us from being subject to the tyranny of the executive branch or the tyranny of the legislative branch. And I think that's why it's considered such a strong provision. The U.S. Supreme Court, in a case called Cooper versus Aaron, back in 1958, confronted a very similar challenge when Arkansas officials sought to ignore court orders involving segregation or desegregation. And the Supreme Court, and I think this is relevant to us, said, it is the province and duty of the judicial department to say what the law is. The governors of the states are bound by the Constitution and the decision of the court interpreting. No state legislator or executive or judicial officer can war against the Constitution without violating its undertaking to support it. That was true in Arkansas in 1958. It's just as true in New Hampshire in 2025. And to forget that principle and to forget what John Adams said, that we're a government of laws and not of men, is to forget who we are. And that's why I'm going to vote in favor of the motion, though I think I can speak for many who believe that a different motion would be more appropriate.
Representative Horgan.
Yes, I'm reluctantly supportive of the interim study motion, assuming I'm still on the committee a year from now, which is we'll be getting together again, and our choice will be either vote recommended for future legislation or not recommended for future legislation. I mean, assuming the interim study passes on the floor in January, so I would anticipate not voting for recommended for future legislation. I think this HCR. I think this HCR is like going down the wrong path. It's wrong-headed. I will say that as a practical matter, the first Claremont decision was 32 years ago. We've been through 17 budget cycles since then, and we've been passing we've been passing budgets that basically are at least unconstitutional and illegal, but within our prerogatives to pass, so no one can stop them from passing them. I think I myself have voted for several of them because we had some where the budget was proposed by the party that I'm a member of, and we had I think we had at least one where there was a bipartisan vote in favor of the budget. So I've actually voted for some of those budgets, so I'm as guilty as anyone else. But I think as a practical matter, anyway, in 2026, in November 2026, we'll be voting on voting on whether or not to recommend for future legislation. So I'm happy to like put this off till then, and then I doubt that I would vote for the recommended for future legislation motion. And then in 2027, this House, regardless of who's, I don't know if any of us know for sure whether we'll be a member of in 2027, we'll be voting on another budget, and I would be surprised if it fully meets what the Supreme Court has said several times, most recently the Conval and Rand case about educational funding. I think we probably still will have what at least the courts believe to be an inadequate amount of adequacy funding, and that's just a fact of life. There's various reasons why we've passed all those budgets, and I expect the same thing will happen 2 years from now. But in the meantime, I'm personally happy to vote for the interim study. So, and you may want to consider like how you want to word the resolution anyway. So I'm in support of the motion, and this issue is not going away anytime soon. It's not going to go away next year or 2 years from now, but that's just the way it is.
Anyone else wish to be heard? Representative McFarland, then Representative Alexander.
Thank you, Mr. Chairman. I have several reasons for believing that the better motion for this resolution would be what to pass. First, our Constitution, in Part 1, Article 37, requires that the legislative, executive, and judicial powers be kept separate and independent. When a court orders us to define or to fund an adequate education, it intrudes upon that separation and it assumes legislative power. Secondly, each of us swore an oath to uphold the Constitution itself, not the recent several decades of judicial gloss upon it. If a ruling departs from the plain meaning or the framer's original intent, then fidelity to our oath may require respectful resistance. We must answer first to the Constitution, not to another branch's interpretation of it. Third, the Claremont decisions went beyond the traditional judicial role. Courts may properly say what government may not do, but not what it must do. A positive mandate to legislate or to tax transforms judges into legislators and erodes the balance that our founders designed. Finally, and historically, when Article 83 was adopted in 1784 and for generations afterwards, education in New Hampshire was entirely local. It was funded by town taxes, and private subscription, with the state playing no fiscal role. Towns maintained their own schools and funded them. The state had no education department, no statewide tax, and no authority over local schooling beyond settling minimal statutory requirements. And for well over a century, that local model reflected both the law and the lived practice of our communities. The framers' use of the word cherish in Part 2, Article 83, was never understood as a command for centralized state funding. The early legislatures read it as a call to promote learning and not to pay for it. It was only in 1993, in their Claremont 1 opinion, that the court reasoned that the framers' choice of the word cherish in Part 2, Article 83, reflected a far stronger duty than merely the word encourage, and from that inference concluded that the state bears a new positive obligation to fund an adequate education. Even in the language of the 18th century, to cherish meant to nourish and to take delight in. It did not mean to command or to compel. When Isaac Watts wrote in Reliquiae Juveniles that the verdant prospect cherishes our sight, he meant that a green and flourishing view refreshes and uplifts the spirit. That is the same sense that our framers used. It is an appeal to nurture learning and to esteem knowledge, and it is not a directive to fund it from the state treasury. That is the natural, humane sense of cherish, a word of affection, not appropriation. The dictionaries of both the 18th and the early 19th centuries support this. Samuel Johnson's Dictionary of the English Language defines cherish as to treat with tenderness, to protect, to encourage. Noah Webster's American Dictionary of 1828 defines it as to treat with care, to nurture, and to encourage growth. And meanwhile, Webster defines encourage as to give courage to inspire with confidence, to promote or foster. They are near synonyms. They are each about moral care and public spirit, and they are not about fiscal compulsion. If anything, between the two, cherish is the gentler word, appealing to duty of affection and not to command of expenditure. And if members of the committee are interested, I brought with me my present-day dictionary, which I will not read out right now, but in all of the definitions of cherish in there, nothing has changed since the 18th century in this regard. That conclusion that they drew overturned 2 centuries of settled understanding and sought to shift what had always been a local responsibility to the state treasury. HCR 11 simply asserts that such a transformation belongs with the people and with their elected representatives and not with the judiciary. For these reasons, separation of powers and the fidelity to our oaths and the rejection of judicial mandates beyond their proper sphere, I am enormously sympathetic to my colleague from Hillsborough, whom I have reason to believe would also have preferred a motion for ought to pass on HCR 11. Nevertheless, Mr. Chairman, this question being far from settled, and the meaning and force of that Article 83 being in question, and whether cherish imposes any kind of moral duty or judicially enforceable fiscal mandate remaining before this House through several items of related legislation, including ones which are forthcoming in the 2026 session, I believe it is therefore prudent that if we do not recommend HCR 11 ought to pass today, that we instead retain it for interim study so that the committee and the full House may consider these constitutional questions again, together, and in full context. We can honor education without surrendering legislation, and I will be voting for interim study.
All right, Representative Alexander.
Thank you, Mr. Chair. I don't think I could have said it better myself. I agree 100% with Representative McFarland. I will be voting no on interim study. I strongly believe it's the legislature's responsibility to define adequate education. We need to reassert that authority at any opportunity we get, because that Claremont decision is wrong, and I think we need to address it as the body closest to the people. Thank you.
All right, anyone else wish to be heard? Yes, Representative Scully.
Thank you very much. Again, Article 37, I believe you had quoted, it did said the purpose of that article is to prevent any one branch of government to become too powerful. So in a situation where the judiciary starts to usurp the responsibilities and power of the legislature, I would respectfully submit that that is a situation where one branch of government is attempting to become too powerful. And I do believe that we have a duty and obligation to maintain the proper balance between the three branches of government. To have one person dictate to all what they believe should be legislation, I think is incorrect. I've heard this meme, "No kings," bandied about many times. I think this is a situation where if you have one person trying to dictate to the legislature and telling them what to do, that person is acting like a king. And I reject that, and I think the people of New Hampshire should too.
Anyone else wish to be heard? Yes, Representative Perino.
Yes, thank you, Mr. Chairman. I will be brief. I just want to say that, and to Representative Horrigan's comment, no, this issue is not going anywhere soon. And this is exactly why I am reluctantly supporting the interim study motion, because I would far prefer a motion of ought to pass, because I do think that it is important that the general court, as the largest body closest to the people. In fact, I had a conversation with one of my constituents this morning on the way in, saying that we need to reestablish ourselves as the general court. But this is important for future and current New Hampshire Supreme Court decisions, regardless of judicial appointees, because we never know who the appointees are going to be and which side of this issue they will be on. So it's of the utmost importance that we study this and establish our position as the general court.
Anyone else wish to be heard? Yes, Representative Andrews.
Thank you, Mr. Chair. The main reason that I want this to go to interim study, whether I agree or disagree with the Supreme Court, they made a decision. I have to abide that decision until someday maybe it can get changed. And in here, I believe we are telling them, we're being point blank, you made a bad decision, and down the road, I think it's going to come back to get us, personally. This HER 11 has a lot of good merits, and I think it needs to go to an interim study so maybe we can get more information and make it a better HCR. Thank you.
Anyone else wish to be heard? Representative Birch?
Yes, I just want to say one thing about Article 37. It's not an issue of power in the sense of one person dictating to other people, and it's not a question of who's closer to the people or not. The Constitution says in the government of this state, three essential powers thereof, to wit, legislative, executive, and judicial, ought to be kept separate. So what they're saying is it's defining the lanes. It's not defining who has what powers and the like, other than to say the executive branch, the legislature makes the laws, the executive branch enforces them, and the judiciary interprets them. That's what our Constitution says. And I may disagree on a whole host of decisions lately coming out of the U.S. Supreme Court, but I don't deny that they have a right to make the decisions they make, even though I may disagree with them. And I think that's what the whole we're talking about nullification, and I just think it's good to remember this is defining lanes, and we should stay in our lane.
Thank you. Anyone else wish to be heard? All right, then I think we're ready for a vote on the motion of interim study on HCR 11, and I would ask the clerk to please call the roll.
Vice Chairman Mannion,
Yes.
Representative Alexander.
No.
Representative Tripp,
Yes.
Representative Andrews.
Yes.
Representative Kutab,
Yes.
Representative Perez.
Yes.
Clerk votes yes. Representative McFarland,
Yes.
Representative Scully,
Yes.
Representative Birch,
Yes.
Representative Newsom,
Yes.
Representative Horrigan,
Yes.
Representative Page,
Yes.
Representative Manos,
Yes.
Representative Tur,
Yes.
Representative Rombo,
Yes.
Chairman Lynn,
Yes.
16 yeas, 1 nay.
All right. I will write the majority report. Representative Alexander, will you write the minority?
Yes, I'd like this to go on the regular calendar, please.
All right, yes, it will.
And my motion is OTP.
And your motion will be OTP, okay. All right. Next, I'll turn to Senate Bill 268, permitting classification of individuals based on biological sex under certain limited circumstances, and the chair recognizes Representative Perez for a motion.
Yes, I move OTP.
Your second?
I'll second that.
Moved by Representative Perez, seconded by Representative Alexander. Representative Perez, do you wish to speak to your motion?
I do. We have hashed this for several years, back and forth, but things have changed dramatically. Things have changed because it's now become a lot about safety for everyone involved. Recently, the NCAA has banned male athletes from women's sports. Just yesterday, the Olympic Committee, who had originally said that they, at a certain testosterone level, blah, 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 now, because of information that was just given to them by their medical person, the likelihood of the IOC will introduce a new policy as soon as January was heightened on Monday after the committee's Director of Health, Medicine, and Science, Dr. Jane Thornton, gave a scientific-based review of the evidence to the members last week, showing there were indeed physical advantages to being born male. So things are changing. They are finding, and it is becoming more enlightened to the fact that having a male, a biological male, compete against a woman is unsafe. And people all over the world are realizing that. As far as the other issues involved, as far as being in bathrooms, I think that is just as unsafe for the biological male to be in a girl's bathroom or a biological woman to be in a male bathroom, for both sides. We have heard of transgenders being beaten up in males' bathrooms. We have heard of biological males putting biological females in extremely difficult positions, being in a locker room or a bathroom, stripping clothes off, not being understood. We're talking about in junior high school. We're talking about a 13-year-old girl being exposed to male genitalia in the bathroom when she's only going to relieve herself. This is coming more and more to the point where we need to separate these things for the protection of our children, our male children, our female children, and for the decency of both parties. So I ask you to please vote ought to pass for this. Other states have, 23 other states. I understand we're live free or die, but there's a limit at which live free or die. Are we going to wait? Are we going to wait until we have a biological female killed on the volleyball court? Are we going to wait till that happens? We had one severely injured. It takes one of those, I don't know what you call it when you plant, but we can't wait. It's time. Thank you.
All right. Anyone else wish to be heard? Representative Alexander and then Representative Tur.
Thank you, Mr. Chairman. We just had a great conversation about separation of powers, and I think this situation is important that we continue to pass this legislation as the legislature has indicated that this is something that we support. it's okay to disagree with the governor of the same party. I invite the governor or the governor's team to send us language that's acceptable to them, but I have yet to see any language. And as soon as, so I think we need to pass this again to reassert our position and give the governor another opportunity to pass this common sense bill. Thank you.
Representative Tur.
Yeah, thank you, Mr. Chair. So, I agree with Representative Perez to the extent that we have hashed this out many, many times. What I don't agree is that things have changed, and it's not that a social question. It's about the bill itself. The same things that I have brought up in the previous hearings, I want to bubble up again. This bill has in its title biological sex. The core of this bill is the term biological sex. There is no effort in this bill to define biological sex. And that's not a minor thing. You know, we're literally talking about making an exception to essentially the gender discrimination prohibitions that we have as rights in our Constitution. So this should not be treated lightly. Beyond, and I'll go into a little bit of detail, but you know, I really want to impress anyone thinking of supporting this that because this is not defined, it will be up to any individual person or institution to make their interpretations about how to use this law going forward. And this is not conjecture, it's happened in other states where essentially the very things that you're talking about preventing to some degree in certain provisions here are exactly what happened in other states under these exact provisions. And those are ones where they did define something, but basically the way it played out, and I won't go through the whole Texas story again, but even if the intent that you have for this is good, the application of this has every potential to do the opposite. So again, biological sex, not going to go down all the different ways you can go there. If we don't define biological sex, it means anyone can define biological sex and use this bill as the vehicle. It also doesn't say how you can ascertain your decision about biological sex. So it means what can you ask? What can you ask someone to do or demonstrate or show in order to make the determination of their biological sex? So we're opening up not just the discrimination part, but the invasion of privacy part. Again, someone has to make a call. So I could look at someone and use one definition of biological sex and decide you are a male. The person next to me or the school across the street from me, you know, if I'm a school, could make the exact opposite determination, and both of those would be equally supportable under this law. So we're opening up a vast can of worms where I don't even see how it would ever be determined who's right. So we don't know how biological sex is determined. We don't know what basis it is. It goes even further. It doesn't say once you've decided someone is male or female, how you should act. You know, I could decide you're a male, and so you belong on this team. You could decide you're a female, you belong on that team. It is, in fact, all allowed the way this is structured. I you know, cannot sort of say more strongly what I've said when I've spoken to this in its previous iterations. This is legislative malpractice from the start. There is absolutely no way that a law this core that goes right to people's basic human rights, that is an exception to, you know, the prevention of invasion of people's basic human rights, should go forward with all of this wide open. You know, it is possible to define all of these things. It's not like there's no way to do it. I believe, and again, I don't want to imply motive, but the reason not to do that is because it's very, very, very messy. this is the world that we live in, and any definition you come up with will have to address all the caveats and loopholes and everything else that would be part of that definition. But I don't think that just skipping over that part and saying, well, it's just biological sex. I believe the sponsor of this bill, Senator, said he knows it. And that's great for him that he knows it. But I know it too in my own mind, but I wouldn't imply my mental views of what I think one person is or isn't, on that person and direct them to use a certain bathroom or to join a certain sports team because that's the way I feel. There's a huge difference between my own beliefs. And again, if I express my own beliefs in some organizational, institutional way, I am in fact discriminating, and that's sort of what this goes. So I'm not going to belabor this, but I really want people to think about what are the implications of a law that lets each person and each organization make their own individual judgments and then apply those judgments in any way that they wish in order to achieve the outcome. And again, it is the reason that Texas's state champion, girls wrestling champion, undefeated 2 years in a row, was a trans man. He was biologically female at birth, and that was the determination. But the opposite could have been applied under this law. So I hope people will think about what's really on the table here and not just sort of go along with the sort of narrative talking points that I think this bill is trying to address. Thanks.
All right. Anyone else wish to be heard? Yes, Representative Horgan.
Well, first of all, we're not bound. The International Olympic Committee made a political decision on a very difficult issue, which it's been dealing with for a long time. So that's not necessarily the decision they made yesterday is not necessarily binding on us. And I assume they made it partially because of the political realities connected to the fact that the Olympics are going to be here in the United States in Los Angeles in 2 years, and there's a lot of political uproar over the trans issue and other things. The term biological sex is, as others have noted, not defined at all in the bill, and I'm not sure even if there isn't really a very good definition of it, and even if it does, I'm not sure why that counts for more than your gender identity or your gender expression, why somehow your quote unquote biological sex. And what we learned probably back in middle, I guess it was probably like in 6th or 7th grade, is women have XX chromosomes and men have XY chromosomes. First of all, that's a relatively recent discovery back in the 1930s when trans issues first became a big problem because the Olympics, that was a new discovery. And even today, the man who discovered DNA just died last week. So there's a lot we don't know about how our biology works. And there certainly are there are people who whose gender expression who basically there are men who do have XX chromosomes. There's women who have XY chromosomes. There's various unusual things that happen, and also so that's so that particular definition, which is not even in the bill, is an oversimplification. So I think I think we should let certainly sporting competitions, they should probably decide for themselves what the appropriate rule is, and the same goes for organizations who have bathrooms. And of course, it's illegal. It's always illegal to harass or assault a person in the bathroom, even if you're the same quote unquote biological sex, regardless of what your chromosomes or your other biological factors are. So I would say this bill's unnecessary and counterproductive. And although I will admit, probably a lot of us are probably wondering, like they brought up the example of volleyball, which of course is a non-contact sport. They're on two sides of the net. So like, how can that be a problem? It is true that if you get hit in the head with a volleyball, they move it great speed and you can't have a head injury. But that's a problem, even if everyone involved is even if everyone involved in the game on both sides of the net has an XX chromosome or conversely an XY chromosome. That's just a problem with the game, and so I'm not sure passing that's something. So I'm not sure. If this bill eliminates that problem. Doesn't eliminate that problem altogether. So injuries are part of sports, and they do need to know to mitigate them. But I don't think a blanket ban on people with certain chromosomes only being restricted to one competition is the right answer to that. So I would say this bill is well intentioned, but I cannot vote for it. Thanks.
Representative Peternal and then Representative Perez.
I would like nothing more than to never hear another bill like this. However, as long as we are going to have people continuing to perpetuate the lie that you can chop off body parts or add body parts to change your sexual identity and essentially creating a different human being, we will continue to have this fight and try to protect women from men invading their spaces.
Representative Perez.
For 3 years, I have listened to my friends on the other side chastise these bills. I would like to challenge you to bring forward a bill that's going to protect women, born women, XX women in sports, and protect men, XY men, however you want to put it, in their sports, and to protect them in private spaces. Women in women's sports are the majority in that sport. But yet we did just have a young girl in New Hampshire who will never play volleyball again, who had a severe head injury from a male on the other side of the net, whipped down and hit her in the head. Bring forward a bill to protect women's sports and male sports, women bathrooms and male bathrooms, and women's private spaces to protect them from the safety, if nothing else. Quit saying that a minority has more rights than a majority. That's not discriminating against them. That is saying that there is a right to safety. There is a reason why girls do not participate in ice hockey, in co-ed hockey over the age of 13, because males can then check and they can get severely hurt. There is a reason why boxing is at a weight level. There are reasons. So bring on a bill that's going to help girls and boys stay safe.
Anyone else? Yes, Representative Tur.
Yeah, just real briefly in response to Representative Peternell's statement. I think that statement sort of highlighted what I was trying to say earlier, which is that interpretation is one interpretation of what male and female is, presence or absence. And I'm not going to guess what body part she was talking about, but I probably know. That is one interpretation of biological sex that you could rely on if you wanted to. And yes, there are things that can be done to change that over the course of someone's life, whether that's present or not. So what I'd like to point out, though, is there's nothing in this bill that mentions people in transition specifically, but obviously that's the subtext of everything, or at least where most of, but certainly not all of the ambiguity in gender identity stems from. All I'll say is whether or not that body part is present or not does not provide an advantage in sports, at least not sports that I know of. There's another aspect of biological sex that might give you an advantage or not an advantage in sports. But again, the presence or absence of that body part, just that body part, does not. And so that is what I was trying to say earlier. By not defining this, we are blending a vast array of different situations and failing to do, if we really were serious about trying to define each of these situations and protecting women's rights, you would have to look at what's the advantage, what's the problem. You know, hormones don't, create problems in bathrooms necessarily. I'm not saying they exist, but to the extent that they do, that's a different aspect of biological sex. So this bill needs, if it has any future life, to basically address the hard problems that we essentially are trying to essentially just paper over and pretend like they don't exist.
Anyone else? Yes, Representative Manos.
Thank you, Mr. Chair. At the hearing on this bill, we heard from many, many, many members of the public who expressed their strong concern with this bill. And the question of risk, putting people's physical health at risk, putting their emotional and mental health at risk, and endangering people. And I just cannot support that. I absolutely cannot support that. This would literally put people's lives at risk, and their health and their mental health at risk. And I just cannot support it. Thank you.
All right. Anyone else who should be heard? All right. I think we're ready for a vote then. The motion is ought to pass on Senate Bill 268, and I would ask the clerk to please call the roll.
Vice Chairman Mannion,
Yes.
Representative Alexander.
Yes.
Representative Tripp. Representative Andrews.
Yes.
Representative Kutab.
Yes.
Representative Perez.
Yeah.
Clerk votes yes. Representative McFarland.
Yes.
Representative Scully.
Yes.
Representative Birch.
No.
Representative Newsom.
No.
Representative Horgan.
No.
Representative Page.
No.
Representative Manos.
No.
Representative Tur.
No.
Representative Rombo.
No.
Chairman Lynn.
Yes.
10 yeas, 7 nays.
All right. Representative Perez, can I ask you to write the report for the majority, and will there be a minority report?
Yeah.
And who will write? Representative Tur, okay. All right.
ITL, I assume?
IGL, okay. And I gotta write it down. All right. All right, so you know what, those who are writing reports, can I ask that you have the reports to me by the end of the day tomorrow? Is that okay? Anybody have any problem with that? All right. Reports. All right. All right. Anything else we need to discuss? Yeah.
I just wanted to clarify,
Yeah.
when do we need to get the reports to Representative Birch so that he can then pass them on to you?
Hopefully by noon tomorrow.
Great. All right. Let me just think. Is there's anything else that we need to talk about? I know. All right. Anything else that we need to talk about before we adjourn? All right. Well, it was good to see everybody again. It's been a while, and good to see everyone. And see you in December. Have a happy Thanksgiving, everybody. And we'll see you. I'm sure we'll be seeing a lot more of each other as we move forward, for sure. All right.
and easy if you don't have to figure out how to vote.
Is that nice? Some you might like.
Yeah, I'm trying to get one of my bills. Don't blow it right now.
You might like one or two.